Welcome to today's workshop on successor trustee training. We find that as today, a lot of you are here because you are our clients, but then some of you are here because you have been named by our clients to be successor trustee. And so this workshop is primarily for you. So you can get some idea of what to expect now, because I find that a lot easier for you to learn now than when you're in the midst of dealing with a crisis. So we're going to talk in generalities here today about these things, but it's designed to help you understand how the plan is intended to work. So the first thing we need to talk about is if you're in this room, you are a trustee of a trust. Let's talk about what a trust is. Okay? So this is the legal mumbo jumbo that comes from a law book. Okay? It's a fiduciary relationship, da 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 da. What a trust really is something that involves three parties. So it's a triangle. And it works like this. Dusty, will you hang on to that for me? Sure. Okay. And if Gail needs anything that you could use this to benefit her for, that's what it's for. It's for her benefit. Okay. We've just created a trust. I'm the trust maker. I was the one who had the asset to begin with, and I entrusted it to Dusty, who's now our trustee. She's the manager in the trust relationship. And Gail is our beneficiary. She's the one who's supposed to benefit from the assets in the trust relationship. Anytime we do that, we've created a trust. Okay? Trusts come in different flavors. So the one we're going to talk about today in the biggest part is a living trust, a trust that's created while our trust maker is alive. The other type of trust is sometimes called a testamentary trust or a subtrust. And then you'll hear me call that a blueprint trust. What we mean by that is that it does not exist yet. It will only be created on the death of the trust maker. But the trust maker has to write all the rules for it now, as in drafting the blueprint, so we know what to build when they die. Okay? Trusts are either revocable or irrevocable. Okay? A revocable trust, which is the ones that our clients have done with us, are ones that the client could change their mind about. At any time they could say, give me that back. I want that back. And then a trust is no longer in existence. An irrevocable trust, such as a Medicaid trust, is one where you have said, okay, I'm giving it away and I cannot take it back. Okay? That's done for asset protection purposes. It can be done for tax purposes. But the whole point of it is at some point being able to say, that's not mine. I gave it away and I can't take it, so now you can't count it as mine. So when we talk about a trust, if we have that relationship, I can say to Dusty, when I give you things, you should use them to take care of Gail. But if I never give her anything, then we've never funded the trust. The trust has no assets. Okay? So an important part of working with a revocable living trust is funding it, making sure that the assets are retitled from the name of the trust maker to the trust itself. So the title would go from Karen Brady to the Karen Brady Trust. It might say to Dusty as trustee of the Karen Brady Trust. But in any case, I need to show on the legal paperwork that it has changed ownership from my name individually to the trust relationship. So as our clients do that as part of funding with us, and then as they get new assets, we keep educating them to do that. If you get a new house, you get a new car, you get a new anything, don't put it in your name, put it in the trust name. Because whatever's not in the trust won't be controlled by the trust, and we'll talk about some of the consequences of that if you die with assets outside the trust. Okay? Some assets will not go in the trust while our trust maker is alive, and the most obvious example of that are qualified retirement plans. Qualified retirement plans, IRAs, 401ks, 403Bs have to stay in the name of the worker who earned that money. They're called the plan participant. That's, I say, remember IRA, what does the I stand for? Individual. It has to stay in the name of the individual. So we won't transfer that to the trust while our trust maker is alive. But we will arrange for beneficiary designations of that asset to go to the trust. Okay? And then if we have assets that aren't in the trust but are in the name of the deceased person, we always have a pour-over will available in order to pull that back into the trust after death. So if we use this trust as the example, here's my handy dandy sugar packet. If I own that sugar packet in my own name and then I pass away, it's not a trust asset. So the trust can't control it at my death. We're going to have to go with probate, and probate is determined by the terms of my will. So the pour-over will is why I call it a pooper scooper. It cleans up and says, okay, let's take that asset that wasn't in the trust and put it in the trust as a result of Karen's death. But we have to go to probate to get that result. Okay? So a pour-over will is a belt to go with the suspenders, and we don't want to need it. We want it to be useless because we've done all of the funding before they die. But obviously we have to have it as a just-in-case measure. Important. So why would someone create a revocable living trust? Okay. For starters, it helps to plan for how to control the assets in the event of disability. So we've got rules in the trust that say if while I'm alive and well, I may be my own trustee. But if I get too sick to act, I can't manage my assets anymore. The trust has already named a successor trustee to manage the assets for me in the event of my incapacity. And it has the rules about what should and shouldn't be spent from the trust in the event that I'm no longer trustee because I'm incapacitated. For example, mine says take care of my spouse too. Mine says take care of my kids. Now my kids are just at that age where they don't need me so much, okay? But until a couple of years ago, I definitely needed to have a provision that said make gifts to my children because they were still in college. And we didn't want to turn the spigot off if I'd gotten sick. So that's one of the things a trust can do. That's how it can plan for your loved ones. It contains your instructions. The other thing about a trust is that it is a contract in a way, so that makes it a private relationship. That whole relationship never has to go before a court, never has to be filed in any public record. So there is a trust registration statement that needs to be filed when an irrevocable trust has assets. But that's a one-page document that says, this is the trust. There is a trust, and if you have any questions, contact the trustee who is this. They don't know anything about the terms of the trust with that trust registration statement. So a trust can be a good way to keep things private. People can say, well, what happened when so-and-so died? Who inherited? Well, with a will, we can go down to the courthouse and find out. But with a trust, it's not on record. So that's one of the things some people like to do with that. So in some types of trusts, we can get a fair measure of asset protection of different types, okay? Even tax minimizations. If you own your property outright, there is clearly no asset protection, right? If I get sued and I have property in my name and they say, well, we're going to take what you have, well, this is what I have. It's in my name. If I get sued and the property is in a revocable living trust, I still don't have any asset protection. And the reason for that is that R, the revocable part, where I could say, well, give it back. Because I have the power to take it back, a court could order me to take it back to give it to my creditors. So there's no asset protection in those kind of revocable trusts. That's why irrevocable trusts can be asset protection devices, because then I can say, I can't, I gave it away and have no rights to take it back. And that's what makes it an asset protection device. But any type of irrevocable trust, including those blueprint trusts that I started to describe, that don't come into existence until after I've died, and so therefore they're definitely irrevocable, right? Because I'm not alive to revoke them. Those can have asset protection for the people that I leave them to. So those people can say, have a stronger argument to say, you hear me waffling on that. I don't want to make you think that there's anything like a bulletproof trust out there. But the whole point of this kind of planning is to be able to have an argument to say, that's not my asset. You can't take it from me. To a creditor, to someone who's just divorcing you, to someone who just wants to take advantage of you, it can be a nice piece of asset protection to be able to say, you know, that money I got from my dad, yes, I got an inheritance, but it was in the form of a trust. So it's not something you can take from me, because honestly, it's not something I can give to you. The terms of the trust prohibit me from spending it on anybody but me. And that's where the asset protection can come from. In some instances, we create those kind of blueprint or irrevocable trusts to protect people from themselves. Certainly, we do that when we're talking about trusts for minors, right? You can say, we're going to do a plan for a couple, they've got young kids. If they die too early and their children are still young, part of our plan says, well, there's going to have to be a trust set up for the young kids so that an adult can manage it for them until they get to be of an appropriate age. That's both because the law doesn't allow minors to actually own property, but I rarely get a client that thinks the appropriate age is 18, which is what the law would allow. So they're going to go a little older, 21, 23, 25, 27. It all seems to run into that sort of range because we want to protect them from themselves. We want to make sure that they're old enough to make smart decisions before we start giving them access to their inheritance. So that's another benefit of the trust. And yes, a trust can be a means of minimizing or avoiding estate taxes. I'm not going to talk much about estate taxes in this workshop. We can find some other ways to get information about estate taxes if you'd like. But honestly, estate taxes don't hit at this stage of the law until you have more than $5 million. Okay? $5.5 million, actually. So for most of my clients, they're not there. And they're not going to be there. So we don't need to talk about estate taxes for the most part. And even when we have married couples, we get to double that up. And so with only a little bit of planning, we can say we've got to protect $11 million before we have to worry about estate taxes. But we would do that in many instances through the use of a trust. So, in administration of a trust is the role of the trustee to administer the trust. In a revocable living trust situation, the person who created the trust maker, is administering it as long as he or she is alive and well. They do it for the benefit of the beneficiary, which is the same person. They're wearing a different hat. I'm trustee, I'm beneficiary, but it's all the same person, okay, while they're alive and well. And they're following the instructions of the trust, which is to take care of themselves. But then we get to situations where if they're alive and not so well, we need to talk about how that gets managed. So if they're alive and well, then the trust is transparent. That just means the IRS doesn't care that it's there. If their trust is transparent, meaning the trust maker and the trust are treated as the same person for tax purposes, then we get to use the trust maker's social security number. So there's no new social security number or tax ID number for the trust while our trust maker is alive. And because the trust maker and the trust are the same thing for tax purposes, we still just have them file their taxes under the 1040. It doesn't matter whether it was a trust asset that produced the income or an individually owned asset. It goes on the trust maker's 1040. When when they're alive and well, that's when we're working to make sure we get the assets into the bucket. Let's make sure we've transferred all the ownership we can to the trust. And then we work to keep the trust up to date, because things change. The law changes, things change in their life, your assets change. So we want to make sure the trust is always fitting what you want it to do. When we get to the point where a trust maker is incapacitated, sometimes I use that term disability, but here we're not talking about a purely physical disability. Let's say that they're in a wheelchair. It has to be in the type of disability that means they can no longer manage their own affairs. Then we look to the trust to tell us what to do. And the first part of the trust we look at is there's a section in everyone's revocable living trust that says, how do we know you're incapacitated? What's the proof? What evidence do we have to provide to remove you as trustee? And so that always, in my practice, will involve a doctor somewhere, because MD impresses the right people at the banks and the mutual fund companies. But we also will encourage clients to think that it's not just about putting the control in the doctors. Let's put the control in the people that you know and trust, the ones who are really going to know if this is weird even for you. Right? So they're going to know it's really time to take the reins away. And then the trust also tells us who's in charge now. If we're taking the reins away from you, who do we give them to? Who's our successor trustee? So that person's job is to make sure that our trust maker, who's still a beneficiary, we removed them as trustee, but they're still a beneficiary, that the beneficiary is well taken care of with the trust assets. Are they getting the right kind of care? What does the trust say about the guidelines of what and who we should spend money on? Okay? And the primary test here is, are we fulfilling the best interests of the beneficiary? Is this serving the beneficiary's needs and wants? So the role of the trustee is, in this case, to make sure that they're going to get all the important documents together so they know what the rules of the game are for themselves. The living trust will have a lot of the rules of the game. But there's also the power of attorney. The power of attorney names a successor, this person's called an agent, to make legal and financial decisions for you when you're too sick to do so. The reason we need both a trust and a power of attorney is there's always assets or decisions that need to be made that aren't about trust assets. So it could be that, remember, the IRA didn't go in the trust while you were alive and not so well, or alive and well, it's not going in the trust. So if you get incapacitated, we need to use the power of attorney to name someone to make decisions for you about the IRA, because the trust won't be able to do that. But there are also non-asset things that have to be made in our lives. The joke I always make, it's about changing your address at the post office and canceling your membership at the YMCA. Those aren't about assets, but they are about our legal rights and responsibilities, and someone has to be able to carry those out for us. So if you're the successor trustee, you're liable to be the successor agent and the power of attorney. You'll need to look at that and determine what the rules are for you. You may or may not be the healthcare agent, right? So we've got a healthcare power of attorney about making decisions about how this person is cared for. That may not be the same person who's the successor trustee and the legal and financial agent. But the healthcare agent has to think about how they have to exercise their rights too. And if you're working with us, we've been encouraging you to work with us to make sure that we have a spreadsheet of the assets that you own as we help you fund them. So that's another document that your successor trustee can rely on to say, okay, these are the things we can at least know from the beginning that I have to start managing, because these are the assets in the trust. When you're alive and when your trust maker is alive but incapacitated, that's when you want to depend on the advisors that they may have already put together. If they've been working with a CPA, that person will be very good at understanding at least how the taxes have been filed, and what assets have been producing income up to this point. They may have a financial advisor who's looking more to the future, how the assets invested, how long can they last, how can we invest them in a way to make them last even longer if we need to. You might want to know who the beneficiaries of the trust are, because it might not just be your trust maker. You might have Will's trust, but Gail's also a trustee, a beneficiary, I'm sorry, I misspoke. So you need to think about their needs as well. You want to talk to the healthcare advisors. What are their medical needs, and how long are they going to last with those kind of needs? Because that's going to have to tell you how to manage the trust. And then we, as the attorney, would also be able to help you through a lot of the process of providing the documentation needed for you to be in charge, tell you the right kinds of questions to ask, etc. As a trustee, it's really important that you start out organized and you keep really good records, okay? Because you're going to be entrusted, okay, with a fiduciary role, which means a role of trust, that if you screw it up, you could be in trouble. Now, I'm not trying to scare you, okay? If you show your good faith, you're liable to be fined, but you do need to make sure that you've kept good records. And the start for that is to inventory the assets. That's where that spreadsheet that we start with can be so useful. This is the assets we knew to be in the trust. Well, let's start from there and say, okay, these are the assets you're working with. Let's find out what they're worth. Because in a year or so, you may be asked to provide an accounting. Okay, you've been trustee for a year now. Where's the money gone? Where, what came in? What went out? What's left? Those are fair questions to be asked of a trustee, because we want to have somebody making sure that they're doing their job appropriately. And the way to make sure that you can answer those questions is to keep good records. A lot of times you can use an accounting firm to help you keep that. They're really good at that. Frankly, I'm not. I'm not good at numbers, and that just sort of thing is not up to something I enjoy doing. The other time that you may serve as a successor trustee is when our trust maker, our original trustee, is deceased. When that person passes away, there's some things you need to do fast and some things you need to do slow. The things you need to do fast are to complete the funeral arrangements. And the trust assets are available for that purpose. It is an authorized use of trust assets to pay the last remains, care of the last remains of our trust maker or beneficiary. What you shouldn't do fast, what you should do slow, is sign something saying, yes, I'll take that on behalf of the trust. For example, let's say that there's a situation where you're the surviving spouse and an IRA names you as beneficiary. And the financial advisor, intending to be of good customer service and do right by his widow or widower, is going to come by the door and say, here, let's do a rollover of the IRA because you're the beneficiary. I would encourage you as a successor trustee of the trust to slow down and not sign anything, accepting anything on behalf of the trust before you talk to us. Because there are some legal techniques that we might want to use to make sure that it's going in the right direction. One of them is called a disclaimer, and all that really means is that you can actually say, I don't want it. On behalf of the trust, I don't want it. And we may have written into the trust that says, if that party doesn't want it, this is where it goes next. And we write that sort of backdoor option as a way to get better estate tax protection or asset protection if need be, so that we have more choices when the time comes. So before our trustee actually goes, yeah, I'll take that, I know it's supposed to go into the trust, I'd like them to at least talk to me. And I may go, in this instance, Will died in a car accident that he was at fault in, and he also injured 4 other people. Or even worse, let's change that a little. Will died, Gail is alive. We don't want the assets to go to Gail's trust because all those people that she was driving and she hit are going to be suing her now. Okay? So we might want to say, let's disclaim into a trust that's got Gail as our beneficiary, but that she can honestly say, no, it's not mine, you can't take it. Those aren't foolproof, but that's where it's a good idea to not move so fast on that. Just like if you were the successor trustee because your trust maker was incapacitated, if your trust maker is deceased, you want to get together the important documents. The living trust, the portable will, the list of assets, any life insurance policies, information on the retirement plan, who the beneficiaries of that are. We'll have information on most of those things available, but that's something that we're going to have the successor trustee look at and understand their role in that regard. Just like if you have a trust maker who's incapacitated, if you have a trust maker who's deceased, you're going to want to have built a team around it. That includes us as the attorneys, the CPA, the financial advisor. In this case, also perhaps the insurance advisor, who's going to help collect on that insurance. Once we get to the point where our trust maker is no longer alive, that's when the trust is not transparent. It is not the same entity as our trust maker, because our trust maker is dead. So we can't have a social security number of a dead person to collect money under. We can't file a tax return of a dead person except for the last year that they died, of the income they earned until they died. So we're going to have to get a separate tax ID number for that trust. That's by filing the SS form. That's where we prepare the inventory. At the time they died, this is what the trust had, because that's your beginning point as successor trustee to say, this is what I had to work with. And you're going to collect the benefits and decide how to invest this in the short term as we're deciding where to put it as we settle it to go to the next in line, the next beneficiaries. So I would encourage my successor trustees not to invest it in anything that could lose money, because I don't want you to do an inventory on the date of death and 9 months later and say, oh look, I don't have as much money as I started with because I put it in the stock market. That's going to be hard to explain to the beneficiaries. So when you're working with the administrative trust, that's the living trust in its phase of administration, okay, you're going to want to make sure that you're paying all the final bills, that you're paying the taxes, you're paying the income taxes of the deceased, and any income taxes that the trust itself has to pay as it earns income. If need be, you want to pay the estate taxes of the deceased. That's how you're going to have a good accounting system, so you can account for what you started with, what came in, what went out, what's left. So when you're ready, you can distribute assets. Assets are going to include the stuff you can touch, the personal property. Tangible personal property is stuff you can touch. Okay. You might be distributing that outright. So usually you would be in the case of tangible personal property. Here's the couch. But you might also be distributing it in the terms to a testamentary or blueprint trust. So we might have a situation where when Will and Gail are deceased, they say, okay, we want to benefit our children, but we want them to have that asset protection that Karen talked about of an irrevocable trust. So as successor trustee, their successor trustee might say, I'm going to write a check to our beneficiary, but it's going to be to the John Smith Trust, not to John Smith directly. And then the trustee of the John Smith Trust, who might be John himself, will go and invest that in accordance with the goals of the trust. So again, the goal is to make sure that you're organized and keep good records, because you've got to explain why the final result is you're writing a check to these entities, and that's the right number to write them. If we have that sort of testamentary trust, where we're writing a check to the John Smith Trust, rather than giving John his inheritance outright, It's because we wanted John to have those kind of protections I described that can be available in an irrevocable trust. The creditor protection, so if someone sues him, he can at least say, it's not mine, you can't touch it. If he gets divorced, he can argue to the divorce court, it's not a marital asset, it's not mine. We may have set it up so that he can protect it from himself, or so that it's not in his estate for tax purposes when he dies. Those are all reasons we can have done a blueprint trust. In the documents that you have, the revocable trust that we prepared, you may see these terms, the marital trust. That would be a blueprint trust for the surviving spouse. So if Will passes away and it says leave everything to a marital trust and Gail is still alive, what that would mean is that Will's assets go into a trust where Gail is the beneficiary, but we tried to give her some of those protections that a blueprint trust can provide. You'll also see references to a family trust. A family trust in a lot of our designs is designed to possibly save some estate taxes. And so honestly, most of our plans, unless they're old and the clients haven't gotten them come in and get them updated with us, we'll only use a family trust as a last resort. It's written in there so we have the option, but we don't intend to use it except for the very, very large estates. So we might have a common trust. Sometimes that's called a pot trust, and that's when we've got little kids. So if my kids were 12 and 14 when I passed away, I would have had a common trust in my plan, because I'd have said, you know, it doesn't matter, Mr. and Mrs. Trustee, how much you spend on each kid individually. If one kid has greater needs, then spend it. Because that's how we are as parents, right? We don't say, oh, well, I just had to buy braces for your brother. I guess go find a reason to spend $4,000 on you so we keep it even. We don't do that. We just go, those are the needs you have. So if the kids are young enough that we think this is just a family expense, we may say let's create a common trust. The money's there for the kids, plural, without having to treat them equally. We might have a special needs trust, a supplemental needs trust. That's a trust that says you have to be careful what you spend this on. You can't spend it on the basic needs, like housing needs and the grocery needs and the basic medical care of the beneficiary. Because we want to be able to say to Medicaid, guess what? I can't spend it on those things, so you can't count this trust as their asset. That's a big reason to have a special needs trust or a supplemental needs trust. Where a general needs trust is a lot more mellow. Use it for what the beneficiary needs. It can be basic needs, it could be special needs, it could be education, it could be nothing. We can say, you know, what they need, this is what you're going to spend it on, without restricting it like a supplemental needs trust does. A convenience trust is one we don't do a lot of. A convenience trust says, you know, use it, take it out as you might see fit for discretionary purposes. If I've got my trustee as the child who inherited and the beneficiary is the child who inherited, so they're wearing both hats, I don't like convenience trusts because we don't have any argument to a judge to go, he can't take it out, Your Honor, it's against the rules. So the issue with your job as a trustee, and there's some handouts that are available to tell you more about that. The issue is that you have to make sure that you're complying within the four corners of the rules of the trust. That is your centerpiece of instructions. What do the terms of the trust say? But most states, Colorado included, have some laws about what a trustee can and can't do. For example, that requirement to file the one-page registration with the court for an irrevocable trust is a law of the Colorado, and it's not something we can get out of no matter what we write in the terms of the trust. Okay. As a trustee, you have that position of trust again. That means you have to be fair. You can't decide you're going to buy the house from the trust for $1 so that you get the benefit of the house and the trust other beneficiaries get 99 cents. You have to try to treat everybody fairly. You have to make sure that you're complying with the tax requirements. That's where the CPA can get really useful. And you want to make sure that you are protecting, preserving, and segregating trust assets. Okay? What segregating means is that you're keeping them apart. You're not commingling them with other assets. So let's just say that I get this a lot from my children who are inheriting blueprint trusts. They say, oh, that's a really good idea. I like the idea of a blueprint trust. Let's take my assets and put that in that trust. And I go, no. We need to keep these segregated. The inherited money, we can put in this irrevocable trust and it will have this protection. If you try to put your money in there, you're going to blow it all up. Because the law doesn't look as kindly on a trust that you try to create for that purpose. The law says that Will didn't have to leave you anything. So if he wants to leave it to you with strings attached, like it can't go to your creditors, we're going to honor that. But you've got to pay your own creditors from your own money. So we're not going to let you do as many things with a trust as Will can do when he leaves to someone else. So if you try to take your own money and commingle it with the trust you inherited from Will, it's all going to be a mess. Okay, so that's what we mean by segregating. And you want to just make sure that you're using the trust assets in a way that's of benefit to all the parties. So, for example, you can't live in the trust house and not pay rent unless you're the only beneficiary, because you can't say, I'm benefiting from the house, but you're not Mr. and Mrs. co-beneficiary. Tough luck. And you just have to keep good records. We're going to say that again and again. Okay? There's always some paperwork involved, but it's not something we can prepare in advance. To prove that there's a blueprint trust isn't really that hard. We prepare a certificate of trust and we get the tax ID number and we're set to go because our rules have been written down for a long time. Our blueprint's been there for a long time. But that's not something that we can say, okay, here it is, use it when you're ready. We have to wait until we can actually say, this person is trustee, they became trustee because of disability, they became trustee because of death, the death occurred on this date. Those things can't be prepared in advance. But that's what we're here for when the time comes.
For example, an IRA, so taxes haven't been paid on that yet.
Nope.
And so if that goes to, for example, let's say dad's IRA, if it went straight to mom, she'd just be subject to personal income tax on that?
That's a harder one to answer and an easy answer. Okay, so when an IRA goes to a spouse, we encourage the spouse to just roll it over into their own IRA. Then they don't have to pay any tax on it until they take it out, like they would for their own IRA. If the IRA names someone other than a spouse, we still encourage them to treat it as what's called an inherited IRA. And depending on a lot of factors that I can't go into today, then they still don't get to have to pay tax on it right away. Nobody has to pay a penalty, that's for sure. If you were to take money out of the IRA, it is only subject to the income tax that you usually have involved. But we usually have written the trusts in a way that you don't have to pay the tax right away. You can treat it as your own IRA and take money out of it over time and pay tax on it over time.
So what's the best way to designate a beneficiary, say on a 401k or an IRA? Is it best to designate the trust as the beneficiary?
That's my opinion. I will tell you I'm in the minority, but I think I have a good reason for saying that. And that is that if you name the trust as the beneficiary, people talk to me. People have approached me at a death and say, what do we want to do? Where if you name the spouse as the beneficiary, your financial advisor thinks he knows what he's supposed to do, and he throws it over to the spouse without ever consulting with me. And maybe that wasn't the right choice. Maybe we would have wanted to disclaim and go to the trust. So what I normally do, Denny, is I name the trust as the beneficiary, the spouse is the contingent beneficiary. And in every circumstance so far, we have had the trust disclaim and let it go to the spouse. But we've had a chance to examine the circumstances. Let me give you the worst case scenario that I can see for that coming down. And there's other ways to solve this problem, but I don't even want to have the problem. And that is that, let's say that I died in a fiery car crash, and I was the cause of that car crash. Someone else is drastically injured in that car crash. Okay? They are going to sue my estate. They're going to try to get everything I have. Now, no, I'm sorry, let me change my situation. I died in it, maybe, I'm the driver, but it also killed my husband, okay? And his IRA named me as beneficiary. So we put at risk his IRA because it's coming to me, right? If we had named the trust as beneficiary, we might get away from that risk. Okay. And there's some laws that we might also be able to rely on even if we didn't do that, but I just like to be able to examine the situation in real time by having the trust as beneficiary. And I've yet to have to use it, but I like having it in the toolbox. Now, if we don't have a spouse, then what we're going to do is either name, let's say the kids are intended beneficiaries. We're either going to name the kids as the beneficiaries or the kids' trusts. I will not name your living trust as the beneficiary if you don't have a spouse. I mean, I shouldn't. That's just not as good a practice as going to the beneficiaries in shares. So if you've got 2 kids, okay, I'd say I want to name it to the Brad Trust and the Steve Trust. They are the beneficiaries of their mother's IRA. That way, when we talk about creating a separate beneficiary IRA, we have a beneficiary IRA for Brad, we have a beneficiary IRA for Steve. Brad gets to roll it out over his life expectancy, Steve gets to roll it out over his life expectancy. If I named their mother's trust as the beneficiary, I wouldn't get that benefit. You're the oldest, right? He's the oldest. We'd have to work on his life expectancy, the oldest life expectancy, if I didn't have separated out.
Can a trust be a partner or be partial owner of an asset?
Sure.
Or does they can't?
And plenty of times we end up with situations where a trust is a partial owner because our still living spouse is also an owner, right?
Okay.
So you might be joint owners of, let's not say the house, but let's say the rental property, okay? Now, your spouse dies, so their trust becomes the owner, their administrative trust, while still your living trust is the owner of the other half.
Okay.
So technically you're the owner, right?
Okay.
So that often happens.
So is there just a general, with the years of experience that you have, when someone dies, does it usually take 1, 2, 5, 10 years for, regular people with not like $5.5 million for this whole entire trust process to be completed?
All the heavy lifting can usually take place in 5 to 6 months. But my advice to all my trustees is that we do not close the trust until a year from the date of death. Because a year from the date of death is the safe harbor date when creditors can no longer come out of the woodwork. So if your trustee were to say, okay, it's 6 months from the date of death, this is what I know came in, this is what went out, I'm ready to write checks to all the beneficiaries, now the trust has $0 in it, and the IRS comes out 4 months later and says, by the way, your trust still owes us money. Where's it going to come from? Because we just distributed all the money. So I advise my trustees not to fully distribute until day 366. That does not mean that we can't make partial distributions or even distributions of most of it if it looks like a good idea. But I would not recommend that we bring the trust down to 0 until day 366. That is my personal advice. We're professional, right? It's more than personal. There's no law that says you have to do that. But I'm trying to look out for my trustees' worst case scenario, and the worst case scenario is not having any money and finding a creditor still needs to get paid.
One other question.
Okay, one more question.
So we're paying for the care plan, which helps us with the maintenance. After we're dead, then our trustees, are they paying you out of the trust?
Yes.
Or, okay, so that's
Yes.
not,
The care plan has ceased at that point after your death, and they'll be paying me based on a new representation agreement
okay,
that they and I agree upon, based on usually a percentage, not a percentage, a fixed fee, that they and I agree upon.
Yep.
Okay. There are some times when I can't represent your trustee, maybe because there's a conflict of interest, and there are a few families I won't represent the trustee.